Friends, I am Vijay Kumar, Deputy Secretary in the Government of India. This is my fifth talk on General Financial Rules 2017. And in this talk, I will discuss Chapter 5, which deals with various aspects of government works. This is the shortest chapter of GFRs. For a better understanding of this chapter, you may like to revisit my earlier talks. I have given their links in the description. One may also find my mobile number in this description and make suggestions and raise queries. Through WhatsApp, which I would love to answer to the best of my abilities. The first rule of this chapter begins with definitions of works. Rule 130, which is the first rule of this chapter, defines original works as all new constructions, site preparation, additions and alterations to existing works, special repairs to newly purchased or previously abandoned buildings or structures, including remodeling or replacement. In terms of this rule, minor works mean works which add capital value to existing assets but do not create new assets. Further, repair works in terms of this rule means works undertaken to maintain buildings and fixtures. In the definition of works are also included services of goods, incidental or consequential to the original or repair works. In terms of Rule 131, administrative control of works means assumption of full responsibility for construction, maintenance and upkeep. It also means proper utilization of buildings and allied works and provision of funds for execution of these functions. Rule 132 is about powers to sanction works. In this regard, the rule mentions that the powers delegated to various subordinate authorities to accord administrative approval, sanction expenditure, and reappropriate funds for works are regulated by the Delegation of Financial Powers Rules and other orders contained in the respective departmental regulations. Rule 133, which is the most important rule of this chapter, provides that a ministry or department at its discretion may directly execute repair works estimated to cost up to rupees 30 lakhs after following due procedure indicated in Rule 139, 159 and 160. This rule further provides that a ministry or department may, at its discretion, assign repair works estimated to cost above rupees 30 lakhs and original / minor works of any value to Central Public Works Department, CPWD, State Public Works Department, PWD, other central government organizations authorized to carry out civil or electrical works, such as Military Engineering Service, MES, Border Roads Organization, BRO, etc., or construction wings of Ministries of Railways, Defence, Environment and Forests, Information and Broadcasting, and Departments of Posts, Space, etc. Alternatively, a ministry or department may award repair works estimated to cost above rupees 30 lakhs and original works of any value to any public sector undertaking set up by the central or state government to carry out civil or electrical works, or to any other central / state government organization, PSU, which may be notified by the Ministry of Urban Development for such purpose after evaluating their financial strength and technical competence. For the award of work, the ministry or department shall ensure competition among such PSUs organizations. This competition shall be essentially on the lump sum service charges to be claimed for execution of work. For award of work on nomination basis, the conditions contained in Rule 194 would apply. The work under these circumstances shall also be awarded only on the basis of lump sum service charge. Rule 134 provides that works not specifically allotted to any ministry or department shall be included in the grants for civil works to be administered by Central Public Works Department. No such work may be financed partly from funds provided in departmental budget and partly from the budget for civil works. Rule 135 provides that ministry or department shall put in place, as far as possible, empowered project teams for all large value projects, and these teams should be tasked only with project execution and not given other operational duties. Rule 136 provides that no works shall be commenced or liability incurred in connection with it until first, administrative approval has been obtained from the appropriate authority in each case. Second, sanction to incur expenditure has been obtained from the competent authority. Third, a properly detailed design has been sanctioned. While designing the projects, etc., principles of life cycle cost may also be considered. Fourth, estimates containing the detailed specifications and quantities of various items have been prepared on the basis of the schedule of rates maintained by CPWD or other public works organizations and sanctioned. Fifth, funds to cover the charge during the year have been provided by competent authority. 6. Tenders invited and processed in accordance with rules. 7th, a work order has been issued. Rule 137 provides that for purpose of approval and sanctions, a group of works which forms one project shall be considered as one work. The necessity for obtaining approval or sanction of higher authority to a project which consists of such a group of work should not be avoided because of the fact that the cost of each particular work in the project is within the powers of such approval or sanction of a lower authority. This provision, however, shall not apply in case of works of similar nature which are independent of each other. Rule 138 provides that any anticipated or actual savings from a sanctioned estimate for a definite project shall not, without a special authority, be applied to carry out additional work not contemplated in the original project. In terms of Rule 139, the broad procedure to be followed by a ministry or department for execution of works under its own arrangements shall be as under. First, the detailed procedure relating to expenditure on such works shall be prescribed by departmental regulations framed in consultation with the accounts officer, generally based on the procedures and the principles underlying the financial and accounting rules prescribed for similar works carried out by the Central Public Works Department. Second, preparation of detailed design and estimates shall precede any sanction for works. Third, No work shall be undertaken before issue of administrative approval and expenditure sanctioned by the competent authority on the basis of estimates framed. Fourth, open tenders will be called for works costing rupees 5 lakh to rupees 30 lakh. 5. Limited tenders will be called for works costing less than rupees 5 lakhs. 6. Execution of contract agreement or award of work should be done before commencement of the work. 7th. Final payment for work shall be made only on the personal certificate of the officer in charge of execution of the work in the prescribed format. Rule 141 provides for the review of projects according to this rule after a project costing rupees 100 crore or above is approved. The administrative ministry or department will set up a review committee consisting of a representative each from the administrative ministry, finance, internal finance wing, and the executing agency to review the progress of the work. The review committee shall have the powers to accept variation within 10% of the approved estimates. For works costing less than rupees 100 crore, it will be at the discretion of the administrative ministry or department to set up a schedule mechanism for review and acceptance of variation within 10% of the approved estimates. With this brief account regarding Chapter 5 of GFRs 2017, I would like to conclude my fifth talk on these rules. In my next talk, I will take up Chapter 6, which is on procurement of goods and services. And these rules range from Rule 142 to Rule 206. In order to keep myself focused on core and essential rules, I have skipped Rule 140. I thank you for patient listening.